Good morning, everyone. My name is Alexia Tisano, and I'm legal coordinator at the European Network on Statelessness. It's a pleasure to welcome you all on behalf of ENS to this webinar, the State of Play Assessment on Statelessness in Europe for 2025. For those of you who are not familiar with the European Network on Statelessness, we are a civil society alliance of over 180 organizations and individual experts working to address statelessness in 41 European countries through law awareness raising and capacity building. We are excited to have many of you joining us today. And so in a moment, we'll be posting a quick poll to find out a bit more about our audience today. I can see it's already posted. So today we are launching updates to 14 country profiles in our Statelessness Index, along with 2 new country profiles for Bosnia and Herzegovina and Kosovo. So that brings the total coverage of the index to 34 countries. The index is one of the key resources that we have on statelessness across Europe. But others are also available depending on your area of work. So please do check our websites to see our other resources. So some technical points. So we are recording today's session and we will make it available publicly afterwards. So feel free to share it with your colleagues. There will be the opportunity to ask questions to our panelists today. For that, you can use the chat to ask questions as we go along. My colleague Nina is actually monitoring the chat, and so she will try to answer them as we go along in writing and if we have time at the end. We hope that you will all stay engaged beyond today's session, so feel free to email us afterwards with further questions, comments, or feedback. The aim of today's webinar is to present key trends and data emerging from the Statelessness Index, reflect on progress since last year, and identify key areas for action and reform at both national and regional levels. We will first hear from my colleague Cameron Nye, our legal policy officer, who will present our state of play analysis. And then we have an amazing panel of 4 country experts who will offer their reflection on what gaps and opportunities there are in their context to improve the situation of stateless people. Before passing on to Cameron, I wanted to take this opportunity to thank our index partners and country experts for all the work they put in the index. We know this is a huge effort, so thank you all for making it happen. So I see we have some results from the poll. So it's quite a mix of people who used the index before, and some are new to it. Actually, the majority don't know it very well. So welcome to those who do not know about it, and hopefully you'll know more about it before at the end of the session. So over to you, Cameron, to present our state of play assessment of statelessness in Europe for 2025.
Thank you very much, Alexia. I will just quickly share my screen. Can you see that okay? Yeah, good. Okay, so just before we reflect on the recent changes and trends, we thought it'd be useful to give you a quick introduction to the index for those of you who may be less familiar with. It seems like there's quite a few of you from the poll. So the index is an online comparative tool that assesses and compares the performance of now 34 countries in Europe against international norms and good practices. So it examines how they protect stateless people on their territory and also what they're doing to prevent and reduce statelessness. So we launched the index in 2018 as a way to give stakeholders an easy way to understand differences in law and policy across Europe, to identify some good practices and also areas that need to be improved in Europe. And so now, 7 years on, the index holds data for 34 countries. And as you can see, 14 have been updated this month and 2 more were launched, as Alexia was saying. So that's for Bosnia and Herzegovina and also for Kosovo. And other countries have also conducted some outreach and engagement activities this year as well. And so last year we had over 14,000 users of the index, and the index continues to be an essential tool for raising awareness and focusing advocacy on the need to address statelessness in Europe. And you can find more details on the index website about methodology, also how to use the index, and a list of norms and good practices that we use to benchmark performance across Europe. So just moving on to the state of play assessment for this year, really the purpose of doing these every year is to reflect on recent developments relating to statelessness across index countries, and to use the data that we gather in collaboration with our partners to identify trends across countries, as well as the remaining gaps that need to be addressed. As you can see on these slides, the countries in yellow are the ones which have been updated or introduced this year. And so generally progress has been quite mixed across several areas of the index, with some notable steps taken towards protecting stateless people and also reducing statelessness, but also some limited progress and also some steps backwards when it comes to preventing statelessness in Europe. And so while we measure 5 themes on the index, which you can see on this slide, today I'm really only focusing on 2 of them. So it's statelessness, determination, and status, and also prevention and reduction, as this is where most developments have occurred this year. So, for example, when it comes to international regional instruments, we haven't really seen many major developments. And also with regards to detention, with the exception of Malta, which has introduced or stopped its health-based detention of asylum seekers, we've not really seen much significant progress in this area. And then on statelessness population data, we would encourage you to go check out the individual country profiles, as has all been published on there. So just to start the assessment, we thought it'd be good to begin with some progress in the mechanisms to determine statelessness. So this is a really important area of the index because statelessness determination procedures are a vital first step towards the protection of stateless people, allowing someone's statelessness to be formally determined and for them to receive a dedicated status as well as some rights based off this determination. But it's also an important area because, as you can see, less than half of index countries actually have a statelessness determination procedure. And so this year, the amount of countries with an STP is 15 countries. And this is only an increase of 1 since last year. And this is because we've added Kosovo to the index, which does have an STP. But in terms of some more general progress in this area, in Belgium, although it's not a statelessness determination procedure, it's introduced a new administrative procedure to apply for a residence permit on the grounds of statelessness, which is a welcome development, but it still doesn't go far enough in the protection of stateless people. But I won't go into too much detail on this, as Hania will be elaborating on this later in the webinar. And then in Albania, the government has recently published an instruction to implement and regulate the STP that was established in 2023. And this is a really important step. And although there is some really positive elements to the procedure, such as an immediate right to an appeal, for example, the instruction has notable gaps that limit access to the procedure, as well as in the protection that it provides to stateless people. So we'll have to wait and see to see how the STP is implemented in practice to fully assess its performance. But in more positive news, we've seen some improvements to existing statelessness determination procedures in Italy and Bulgaria. So in Italy, for example, the Ministry of Interior no longer requires a birth certificate to access the procedure, and as recently also taken the view that lawful residence is no longer required to access the procedure as well. So these should some welcome developments which could really increase the accessibility of the STP in Italy. And then in Bulgaria, through case law, it's recently been established that where there are cases of doubt, the burden of proof is on the authorities to determine statelessness within the SDP, which goes some way to reduce the barrier of high burdens of proof on applicants in the SDP. And this is also a really good example of how the courts are playing an important role in shaping and improving these procedures. But in terms of some less positive progress, we've seen in Portugal and Ireland, some steps haven't been taken to operationalize some STPs. So it's important to capitalize on this progress as well. So for example, in Portugal, they're still yet to introduce the secondary legislation to operationalize the STP. So moving on to a different theme, this year we've seen some progress in efforts to reduce statelessness in some European countries, which is another really important theme that we measure in the index. So for example, in Germany, recent changes to the Nationality Act have reduced the amount of time that it takes to naturalize as a German citizen for people who work in Germany and who are well integrated. So this has been reduced from 5 years to 3 years, and this should hopefully benefit some stateless people in Germany. However, it's important to also note that the amendments also introduce new requirements regarding some adherence to liberal democratic principles, which may serve to block some people from naturalizing if this is strictly implemented. And then we've also seen some progress in naturalization through the courts in Italy. So an Italian court has recently reaffirmed that statelessness status is declaratory, and that a stateless person in this case did not need to wait 5 years in order to naturalize as an Italian national. So now the important thing is to implement this quite generally across practice in Italy to really reduce statelessness in the country. And then moving on to North Macedonia, the index update this year includes information on a series of measures which have been adopted over recent years to reduce in situ statelessness. And some of them have been quite successful, as you'll see. So there was the facilitated naturalization of over 250 stateless people in the country. And the government has also introduced some new routes, which are aimed at reducing and also preventing future cases of in situ statelessness. But now the importance is on implementing these and also monitoring their progress. However, in some more negative news, Ireland has recently passed a law which has amended provisions on deprivation of Irish nationality, which, despite being criticized for a lack of procedural safeguards, provides for the possibility of depriving naturalized Irish citizens of their nationality, even if this could result in statelessness. So our final theme for the assessment this year is on access to nationality, which is particularly where children are concerned. So it's a very important issue when it comes to preventing statelessness in Europe. And this year we've seen some mixed developments in the index. So starting with some less positive updates, we've seen some new risks of statelessness emerging for some groups of children in Spain, for example, which is usually tended to be a front runner in terms of children's right to a nationality. But new information has shown that although there's a very strong legal framework to prevent statelessness in Spain, the implementation of this framework is inconsistent in practice. So there has been some administrative and legal hurdles in some cases which have hindered or at least delayed a child's ability to access a nationality. And the index also shows that this is disproportionately impacting the children of Sahrawi parents in Spain. And then in Ireland, it's recently emerged in the index update that the government has stopped issuing passports to children who are born to refugee parents. And this is because of a case that is currently pending before the courts on this issue. And although the impact of this measure is yet to be seen, it could be harmful to these children's automatic right to acquire nationality under domestic law. And next, and unfortunately, what's become quite a persistent theme for some index countries is some specific challenges for children who are born to same-sex parents in several European countries. But I won't go into detail on this just for time reasons, but we've seen some issues relating to birth registration of children in Bulgaria and Poland, and also some issues relating to surrogacy agreements in Ireland and Italy as well. But just to end the assessment on a more positive note, we've seen some improvements in terms of access to nationality in North Macedonia regarding a simplified birth registration procedure, which is really aimed at ensuring the registration of every child, regardless of their resident status or the identity of their parents. And also Moldova has recently closed some gaps in its laws, which now mean that children born stateless in the country should have access to Moldovan nationality by application after undergoing the statelessness determination procedure. So just to end this assessment, and while that was a very quick overview of the main issues, we thought it would be useful to see where this leaves us for 2025 and the years coming. So really, we've done this by identifying 3 urgent action areas that need to be improved. So firstly, we're calling for better identification and determination of statelessness across Europe. As we saw earlier, it's still on a minority of index countries that have a dedicated SDP that leads to status and protection. And these procedures are needed now more than ever with the new EU Migration and Asylum Pact, which for the first time has introduced a new legal obligation for member states to identify indications of statelessness. So establishing an SDP can go a long way towards implementing this obligation. Secondly, we're saying that European countries need to continue work to ensure and protect the child's right to a nationality. And there is no full safeguard in half of European countries for stateless children born on the territory. And in 3 countries of the index, there's no safeguard at all. So it's really about capitalizing some progress that we've seen in recent years, but also acting against some challenges in terms of children's right to nationality in some countries, as I mentioned earlier, in Spain and Ireland, for example. So it's important that countries implement further safeguards to protect the right for children. And then thirdly, in 2025, an area that we're saying needs urgent action is the safeguards for stateless people in detention. And so while we didn't see many updates on this last year, it remains one of the most problematic areas among index countries, as statelessness is rarely considered to be a factor that increases vulnerability in detention, and only a handful of countries require a country of removal to be identified prior to detaining someone. And given reports that the EU Commission will be proposing a new legislative package on return to detention in the next year, it's important that these safeguards are introduced at the national and regional level to really prevent the arbitrary detention of stateless people in Europe. And just to really quickly end, 2025 will also see some updates to the index, so I would recommend that you look out for these. So we're publishing an update to our thematic briefing on statelessness determination. We're also launching a resource to do with identity and travel documents, and we'll also be updating 18 country profiles in the following year. So look out for that next time. Thank you, Alexia.
Thank you, Cameron, for this overview. I hope you can all hear me okay. Yes, okay. So let's now turn to our panel of invited experts to hear their reflection, responses, and recommendations for the way forward. So first, we're going to hear from Adam Labaran, who is the Vice President of Refugees Union in Portugal, so UREP. And they conducted an event under the index last year, and they will share more about key challenges faced by communities affected by statelessness and upcoming opportunities in the country. Adam, up to you.
Hello, everyone. Can you hear me?
Yes.
Perfect, perfect. Sorry if you see my camera with the scene like this, so I'll just turn it this way so you can just see me from this angle. Great. Nice to meet all of you. And once again, thank you for giving me the space to be able to be part of this great work with statelessness and stateless people, which we are really doing our best to make sure that we solve all the problems. So back in November 2024, we of course had an event in Portugal. This webinar that we had in Portugal was a very short one, which went great, where we were able to come up with the idea of, discussing how to explore and strengthen statelessness advocacy in Portugal. So the main purpose of the meeting was to identify and engage relevant stakeholders, develop and collaborate agenda to address key challenges faced by stateless individuals and policy gaps, also to establish long-term partnership for advocacy and policy. So we had three panelists on this webinar that we had. One of them is an activist who is a Portuguese activist. So we heard from him as well. He discussed the role of the civil society in supporting stateless individuals and advocating for policy reform. And then we also had another panelist who is part of the International Organization for Migration. So she highlighted the challenges in integration and how NGOs and government initiatives can collaborate as well in the work that we are doing or in the work that we intend to do in terms of the advocacy work for stateless people in Portugal. But then we also had our own colleague, one of them, which is Diaby Abdurrahman from the Portuguese Association of Refugees. He then addressed barriers to accessing education, healthcare, and employment for stateless individuals. So these were very important topics. Then we also had a Q&A session where we had a contribution from one of the panelists who wasn't available by then. So she joined, but she's from UNHCR. So she then added her contributions to it. And discussed also, what policies are being, approved, or what regulations, or what is happening at the moment between UNHCR and the Portuguese government for stateless people, because we had this new law that was, approved by the parliament for stateless people. So this is what happened on that webinar and that event, and session that we had in terms of the promotional advocacy for statelessness work. But then we had an idea and plan for the next step, which is to strengthen collaboration among these participants. We had, I think, 19 participants, more or less, if I'm not mistaken. And so we all came up with an idea through discussion at the end on how to strengthen collaboration among all of us. The participant, the panelists, also to develop joint advocacy initiatives and policy recommendations, and then also to maintain engagement through follow-up actions and campaign planning. So if, let's say, we can come up with more ideas like that, and as we do believe a lot needs to be done, and the only way to achieve our goal is by working together as one. That is what is more important. Yeah, so thank you. Thank you so much, Alexia.
Thank you so much, Adam. Thank you for sharing about this very relevant and interesting event, and for sharing these great recommendations for the way forward. We're going to hear next from our experts in 2 countries we have added to the index this year. So that's first Bosnia and Herzegovina, and then Kosovo. So I'm delighted to welcome first Bakir Mkonja, legal advisor at Vaša Prava, our country partner organization in Bosnia and Herzegovina. Bakir, please.
Good morning, everyone from Sarajevo. My name is Bakir Mrkonja, and I will give you a short presentation about statelessness in Bosnia and Herzegovina, as well as the challenges we face when working on the Stateless Index survey on behalf of the Association Vaša Prava of Bosnia and Herzegovina. Before I begin, I would like to briefly introduce you about Association Vaša Prava. We are the largest state legal aid provider in BNDAJ. We have 6 regional offices across the country with nearly 30 lawyers. Finally, we have been providing legal aid and legal expertise for over 25 years. Talk about Statelessness Index survey. I was engaged as a leader expert in Bosnia and Herzegovina and Adisa Fakic, senior advisor at the Ministry of Civil Affairs in Bosnia and Herzegovina at the sector for the citizenship and travel documents. She was engaged as a second country expert to work on an index. Given that presentation is limited to 10 minutes, I will present you a few slides and highlights the law, policies, and practice regarding the statelessness issues in Bosnia and Herzegovina. On the screen, you can see the territorial and constitutional structure of Bosnia and Herzegovina. As you can see, we have state level, 2 entities, Federation of Bosnia and Herzegovina and Republika Srpska. Also, we have Brčko district on BNDAJ, and that is some kind of separate entity. And within Federation of Bosnia and Herzegovina, we have 10 different cantons. Given that Statelessness Index survey is a comprehensive document that treats many areas, the challenge was to identify and research an array of legal regulation at the state, entity, and cantonal levels, as well as the practice of relevant institution in order to obtain accurate information relevant to the Stateless Index. Specifically, 14 authorities have different competencies across healthcare, social assistance, and all other rights, and sometimes they overlap. When it comes to the legal framework in Bosnia and Herzegovina, we have international and regional instrument conventions, local legislation at state level, entity level, cantonal level, and Brčko district levels. When we talk about international instruments, BNH is state party to almost all relevant international regional instruments with no reservation, except for the Council of Europe Convention on the Avoidance of Statelessness in relation to state succession. During work on this Parthian server, the challenge was to determine whether the basic principles of the conventions were incorporated into domestic legislation or applied directly. When we talk about overlap of laws and regulation in Bosnia and Herzegovina, I will give you an example. The area of migration and asylum is at state level. The area of registry books and citizenship is at the level of entities and Brčko district and BNDAJ, while access to rights in the area of education, social assistance, and healthcare are jurisdiction of the Federation of BNDAJ and under direct jurisdictions of cantons. Given the relatively small number of persons who have been granted residence for humanitarian reasons as stateless persons, the challenge was to investigate the practice of the authorities responsible for recognizing the rights of these persons. For example, the right to healthcare. Bearing in mind that Bosnia and Herzegovina has received candidate status for the membership in the European Union, the authorities of Bosnia and Herzegovina should work on harmonizing their regulations with those of EU. Slide number 4, I don't know if you see.
Yes.
Although the index is a comprehensive document, slide number 4 lists the most important issues in practice. Limited data collection, no dedicated statelessness determination procedure, inadequate legal protection in detention, barriers to birth registration, stricter discriminatory residence registration requirements, obstacle in naturalization, and insufficient access to legal aid. I don't know if I have enough time. As we move on, I have provided in-depth explanation for each of these problems. If we have 5 more minutes, I don't know how many time we have.
Yes, Bakir, you have 5 more minutes.
Okay. Stateless population data. When we talk about stateless population data and collection of data on stateless persons, there is no centralized data collection system on the number of stateless persons. The Ministry of Security of Bosnia and Herzegovina has certain data on stateless persons in the migratory context, for example, asylum seekers and persons caught illegally crossing the border, while the data on the number of stateless persons in situ population is very difficult to find. Hence, the most relevant data comes from the Association Vaša Prava of Bosnia and Herzegovina. Stateless determination procedure. As you know, in Bosnia and Herzegovina, there is no dedicated stateless determination procedure. And according to the law of foreigners, law on asylum, and law on citizenship of Bosnia and Herzegovina, identification of stateless person is possible in the procedures for temporary residence on humanitarian grounds, asylum procedure, and temporary protection procedure. Also, the challenge we face in relation to status determination procedure is complicated legal framework for officials and beneficiaries, limited awareness of authorities, non-existence of free legal aid in accordance with the law of foreigners. However, Association Vaša Prava provides free legal aid on the ground across the Bosnia and Herzegovina. Next slide, detention. One very important area covered by surveys index is detentions. The law stipulates the other option to detention should be considered first in line with international norms, such as the European Convention on Human Rights, but it is not often applied in practice. The detention of foreigners, including stateless individuals and asylum seekers, is governed by various legal instruments, predominantly the law on foreigners and the law of asylum. These laws aim to regulate the conditions under which individuals may be detained while ensuring the detention is applied only as a last resort. The foreigner can be placed under detention in a migration center for period up to 90 days. The total duration of detention in a migration center cannot exceed 180 days. But in cases of exceptional extension of detention, the total duration in immigration center cannot be longer than 18 months continuously. I will go to the next slide. When we talk about the prevention and reduction of statelessness in Bosnia and Herzegovina, performance on the prevention and reduction of statelessness is mixed, as we have some positive legal solutions and some are still barriers to accessing their rights. You can see the most important topic points, barriers, and we have problem with children born abroad to Bosnian citizens. They have faced administrative difficulties in registering their births, particularly if required documents from the country of birth are unavailable. Children born in Kosovo to presumed Bosnian citizens encounter challenges due to not recognition of Kosovo issued document in destroyed registry books. Inadequate safeguards for children. While there are some protection for foundlings and adopted children, there are only partial safeguards to prevent children from being born stateless on the territory. The requirement for documentary evidences and fees for citizenship application can deter parents from registering their children. Now we move to the final slides. In my opinion, here you can see listed potential steps to address the statelessness issue in Bosnia and Herzegovina. Develop and implemented a legal framework specifically for determination statelessness, ensuring that individuals can be identified and granted appropriate status. When we talk about improvement of birth registration process, simplify the birth registration process, particularly for children of undocumented or irregularly resident parents, to ensure that all children are registered immediately upon birth. Provide training for civil registrars on the importance of inclusive birth registration practice. Also, we have some problems with residence. We should review and amend the legal requirements for residence registration to make them more accessible, particularly for marginalized communities. And here are 3 more recommendations you can see on screen. I don't know if it's necessary to read it. And that's it for today from me. Thank you.
Thank you very much, Bakir, for this rich presentation. So next, I'm very happy to introduce Gens Broki, the program manager at Rome Adversitas, who is our country partner in Kosovo. Gens, over to you.
Good afternoon. Thank you, Alexia. It was a pleasure to be part of this project, developing first index for Kosovo. I would like to thank my colleague, Mentor Seferi from CRPK Kosovo, who supported us in many things in legal advising. And also, I would like to thank Milanka Bazdak from UNHCR Kosovo, the lady which make it as easier accessing information within UNHCR and other partners. Let me share the statelessness in Kosovo, challenges, legal framework, and solutions. During the research, we went through a lot of things, and I would like here just to go shortly through historical and legal context. Kosovo had undergone significant changes in civil registration and nationality laws, particularly after the breakup from Yugoslavia. Before 1999, civil registration and identity documents were issued by the Socialist Federal Republic of Yugoslavia. Many non-majority communities, particularly Roma, Ashkali, and Egyptians, faced systematic exclusion from civil registration. Between 2000 and 2008, United Nations mission in Kosovo took over civil status registration and document issuance. Many registry books were either lost or transferred to Serbia. That was making difficult for people to prove their legal identity. After Kosovo independence, after 2008, Kosovo created a new legal framework to address issues of nationality and statelessness. The 2018 law on citizenship incorporated key safeguards from the 1954 UN Convention relating of the status of stateless person and the 1961 Convention on the reduction of statelessness. Kosovo went during this past 30 years through 2 or 3 different procedures, and it was very difficult for people, and it was a lot of issues with statelessness. Population at risk of statelessness. Statelessness in Kosovo mainly affected historically marginalized communities, particularly Roma, Ashkali, and Egyptian communities. The key risk factors was lack of civil registration records, especially for those born before 1999, displacement due to conflict or migration, bureaucratic obstacles preventing late birth registration, lack of documents from parents making it more difficult for children to be legally recognized. Without legal identity, individuals cannot access education, healthcare, or employment. They are also unable to travel, vote, or own property in Kosovo. Birth registration and challenges. Kosovo law requires that all birth must be registered within 30 days. Late registration, if a child is not registered within 30 days, parents must follow more complex legal procedures to obtain a birth certificate, often requires court involvement in some cases if they are late registered. Support from NGOs. Since 2005, many NGOs have helped unregistered individuals to navigate the system, but many families still lack necessary documentation. Administrative and court delays make it harder for people to gain legal recognition. Kosovo status in international conventions. As I stated before, Kosovo went through 3 different stages. Due to its political status, Kosovo cannot sign international tractates and independently. 1954 UN Convention on Statelessness, Kosovo is not part, but has integrated many of its safeguards into domestic law. 1961 Convention on the rate reduction of statelessness, Kosovo is not part, but relevant safeguards have been incorporated into the civil status and citizenship laws. Kosovo is not a member of Council of Europe, but applies certain human rights protection through its constitution. All this is making many parts easier for statelessness people to register, but it's not enough. It needs more improvement. Statelessness determination procedures, SDP. Kosovo has a dedicated statelessness determination procedure to provide legal pathways for statelessness individuals. The Ministry of Interim Affairs, especially the Department for Citizenship, Asylum and Migration, they are in charge for SDP. The procedure is free of charge, available in 3 languages, Albanian, Serbian, and English, and individuals can apply orally or in written. It's not a very complicated procedure. What it makes more challenging the SDP is limited awareness, long processing times, and lack of internal institution cooperation. Central institutions, they do not have very good cooperation with local levels, and many times people in local level cannot advise properly people to access for the application of documentation.
And apologies to interrupt, but if you could wrap up in the next minute, thank you.
Okay. Soon I'm finishing. I don't have a lot. Protection and rights of stateless people. Once recognized, a stateless individual receives temporary residence permit with limited rights. Stateless person receives 1-year biometric identity card, can be renewed for 5 years. After 5 years, they can apply for permanent residency. They have right on employment, right to work, education, access to primary, secondary, and higher education, healthcare access to medical services, but not social security benefits. No right to vote. Stateless persons cannot vote in elections at any level. Many stateless individuals struggle to access their rights due to lack of awareness and administrative barriers. Key challenges and recommendation. Lack of reliable data. Kosovo does not have any standardized system for tracking stateless people. Bureaucratic barriers. Many affected people lack of necessary documents to start the legal process. Limited institutional cooperation. Authorities do not always coordinate efficiently. During the survey, we came to some recommendation. Simplify birth registration procedure, remove unnecessary evidentiary requirements. This especially limit for registration within 30 days. Improve legal framework. Fully implemented the SDP with clear guidelines for decision makers. Enhance awareness and support, increase outreach programs, and provide free legal assistance. We concluded that statelessness remains a critical human rights issue in Kosovo, disproportionately affecting marginalized communities, while the legal framework has improved. Implementation challenges remaining. Still, addressing these issues requires strong institutional coordination, simplified administrative procedures, and greater public awareness. This is from me for Kosovo. Thank you very much, and thank you for your time.
Thank you, Gens, again for a very rich presentation. Finally, we're going to hear from our lead experts in one of the countries for which we are publishing an update this year, so that's Belgium. So I'm delighted to welcome Hania Hounaoui, the legal officer at Nansen.
Thank you, Alexia, and thank you also to ENS and the great team for organizing this. So I guess now you should see my slides, right? And so I will now talk for a few minutes on the recent developments and key challenges of statelessness here in Belgium. Before all, I will give you a bit of context. In Belgium, statelessness may be determined through a judicial procedure. A person can be determined to be stateless by one of our 6 family courts. It's important to know that there are no specific procedural safeguards in place, and the person recognized as stateless does not derive any rights from this recognition, in particular, no automatic residence status. But civil courts, in some specific cases, condemned the Belgian state to deliver a residence permit to a certain group of recognized stateless by the family courts. However, stateless persons can apply for a right to residence through the humanitarian regularization procedure, but there's no time limits for such applications, and there is no guarantee of being regularized. So in 2009 and 2012, the Constitutional Court has ruled that there is a gap in current legislation, as there is no right to residence for the recognized as stateless through the judicial procedure, provided that they have involuntarily lost their nationality and that they are not in a position to get a durable residence right in a country other than Belgium. And so, more than 14 years later, after the ruling of the Constitutional Courts, and to fill in this gap identified by the Constitutional Courts, we have a new law. On 10 March 2024, a law passed that introduces a new administrative procedure to grant residence permits on the basis of statelessness. Although the main objective of this new law is to create a new pathway to residency for recognized stateless persons, one of the effects is that it creates a new stateless determination procedure alongside the existing one, which is the one from the family courts. So how does it work? Well, you submit an application for admission to stay on the grounds of statelessness directly to the immigration office by registered mail. And if the IO, the immigration office, decides to take the application into consideration, an opinion is then requested from the office of the Commissioner General for Refugees and Stateless Persons. On the basis of this opinion, the IO will then take a decision on the stay. And if the decision is positive, then the stateless person is granted a temporary residence for 5 years, and after which he will be granted a permanent resident permit. People granted a residence permit under that procedure are also granted the rights to family reunification and other rights like the rights to healthcare, to social security, to education, to housing, and the rights to votes. So there are positive and negative aspects of this new reform and this new law. Well, while introducing a residence permit for stateless persons, this law creates a complex and intricate mechanism and imposes conditions that go beyond the 1954 Convention and the UNHCR guidance. So on the positive aspects, well, there is now a residence permits that are available for stateless persons. the CGRS is involved in the process and it has more expertise than the family courts and than the immigration office. And there are also a lot of rights derived from the procedure, including the right to family reunification. But on the negative aspects, we can underline, among other things, that the burden of proof lies almost entirely with the applicants. The new law adds 5 other conditions to the definition of a stateless person by the 1954 convention. The need to prove their identity and origin, the need to prove that they involuntarily lost their nationality or have never possessed a nationality. They cannot acquire or regain a nationality of another state, and that they were unable to obtain a legal and permanent residence permit in another state with which they have links with. And finally, that they're not a threat to public order or national security. Furthermore, the applicant is not granted any rights through the whole procedure, so they won't get any right of stay nor any certificate demonstrating that they have been submitted an application. There are also a lot of limited procedural guarantees, like the right to appeal, which is limited to a check of legality, and there is no right to be heard. One other negative aspect is that the immigration office will not even consider the applications in a great number of cases. So these are major flaws that we saw in breach of constitutional principles of equality and non-discrimination, and also in breach of international standards on statelessness. So one other interesting recent development in Belgium concerns the prevention of statelessness for children born in Belgium, because we have a special provision for that, which is Article 10 of the Belgian Nationality Code, which provides that a child born in Belgium is granted the Belgian nationality if they have no other nationality before they reach the age of 18. And such Belgian nationality will only be lost upon acquisition of another nationality. But since August 2023, we saw that the Immigration Office has exchanged correspondence with several municipalities in Belgium to withdraw the Belgian nationality of children born in Belgium to Palestinian parents who had acquired it on the basis that they were otherwise stateless. So the reasons were that the children would have the Palestinian nationality, and that the office is also concerned that if granted Belgian nationality, there will be abuses from the parents who would use it for getting family reunification and then a legal stay in Belgium. One of the main concerns about this is that the civil registers from the municipality are the only competent authority to grant nationality, and the public of prosecutor are the only competent authority to provide legal support to civil register, and not at all the immigration office. So based on the same article, over winter 2024, we saw a new practice emerging. It's the one with some children born in Belgium to Paraguayan parents were denied Belgian nationality because their parents were accused of frauds to obtain residency, and also because the children could supposedly acquire Paraguayan nationality easily. However, this interpretation of the provision, the Article 10 of the Belgian Nationality Code, is incorrect because it misapplies the principle of fraus omnia corrumpit, and it also misunderstands the Paraguayan law. So there are other key challenges and developments, those past few months here in Belgium, with a lot of reforms adopted in 2024. But I invite you strongly to read the updated index on the ENS website to find out more on those, and we'll be very happy to talk about it further here at Nansen. So don't hesitate to reach out. And thank you, Alexa. With that, I will give you the word again.
Thank you very much, Hanya, for your contribution. And it's good to hear that so many developments have occurred in Belgium. Thank you all for your contributions today, and also to our listeners for your active participation in the chat. So there is a lot to reflect on, and it's clear that states now need to move to a better implementation of the many commitments and pledges that we've heard in recent years. So a big thank you to our speakers for your contributions today and your tireless work and all the points you made. And thank you again for all your work on the index. We will be posting a quick survey shortly to get your feedback on the webinar. So please, if you have just a minute or two to complete that for us, that would be really great. Just to say that we are in the process of uploading the final updates, and they should all be live by the end of the day. We also encourage you all to access and share the index online, use it in your work, and please do send us any comments, feedback, or tell us about how you've been using the index in your life or in your work. Keep an eye out for this year for some further updates, updated thematic briefings, and more advocacy and awareness raising events at national level. We will be updating the other 18 countries this year too, and adding new country information as well. So thank you again very much to all our panelists for sharing your insights and expertise and your commitment to addressing all the issues we discussed today. Thank you very much for all of you who joined us today, and have a lovely day. Bye.